Okay, let's discuss alternative dispute resolution, ADR. This is a way of solving disputes not so much through the formal court process, but through the process of negotiation, mediation, arbitration, terms you may have heard. These are different ways to resolve a dispute. Okay, alternative to what then? Alternative to expensive, time-consuming litigation. You often think of litigation as something that involves a lot of money, time, effort, and a very painful process. Alternative dispute resolution is to get to a resolution much quicker, faster, cheaper, and easier in some instances. It sort of bypasses around the formal rules of court, the rules of civil procedure, and the rules of evidence. In a sense, then, you get around and you don't have to have a federal or state judge there. You have more of a facilitator or an arbitrator. So you get out from having to have the formal judge. Also, the idea of litigation where you're trying to kill the other side is ameliorated somewhat, because what you're trying to do now instead is work with a different type of model to get to a result that is mutually beneficial, especially if you're dealing with a mediation. Okay. The idea then is to get to a settlement that both sides could live with a little bit better, especially if you're dealing with settlement and mediation. We'll talk a little bit about arbitration, which is sort of a mixture of more formalized process. Doesn't get you all the way to litigation, but it's a little bit more formal than the mediation and the litigation. The other thing here to remember is the savings, the economic cost, especially with businesses. Some of them don't want to fight for principle. They don't want to fight to say, I think you did this because it was wrong, or I want my day in court. It's more of a business decision for them. So for them, disputes just hurt their bottom line. They want to be able to resolve the dispute, but do it in an economically efficient way. Okay. Let's go a little bit more specifically and talk about each type: the negotiation, the mediation, and the arbitration. Negotiation is just where the two parties themselves are talking to one another and trying to settle. They come, anytime you go and buy a car and negotiate, you're in a sense doing the same thing. You're bargaining. You're saying, what is the claim worth? If you're the defendant, how much exposure to liability do I have? And is there a way that I could pay to make this lawsuit go away? That's negotiation. Something related to negotiation is mediation. Now, how is it different? It's different in one important respect, and that is a third party is present, a mediator, someone who is facilitating what in essence is still a settlement negotiation. So a mediation is just a settlement negotiation, but it's done with a third party, a neutral third party there, that is trying to facilitate or help the settlement come about. That's mediation. Arbitration then moves into a much more familiar or formal procedure, and much more familiar with the litigation type of way of resolving the dispute. Here, the arbitrator, instead of just being Mr. Helper, is instead a person who is going to decide the case, because both parties in an arbitration agreement have decided we will have our dispute resolved by an arbitrator, and we trust that that arbitrator, following arbitration rules, which are not litigation rules, they're sort of abbreviated litigation rules, will come to a decision and give us that decision. They're not a formal judge, they're an arbitrator. And hence, they seem like a judge because instead of just trying to facilitate a negotiation or a settlement, they are instead deciding the case that the two parties have agreed to allow or to let the arbitrator decide for them. That's arbitration.